This is Steven Leskin. This is the time for my divorce deep dive seminar. And tonight's seminar is on uncontested divorces, mediated divorces, and litigated divorces. So my deep dive series is uh, an informational evening, informational hour, maybe informational half hour. We take a deep dive into a particular divorce subject. And tonight is about the three different types of ways to resolve a divorce case. Uh, so again, my name is Steven Leskin, and I've been a divorce lawyer in Portland for 30 years. Um, my practice has solely been on divorces for about the last 10 years. And uh, divorce also includes custody and other cases that involve family law. I was admitted to practice in the Oregon State Bar in 1992. I've been practicing family law since about 2001. I am the founder of One Day Divorce Mediation, and my contact information is here. The way I do these seminars is I don't take questions, but you are welcome to call me in the future and to say you're on seminar. I'll be happy to answer your question. I'll take all the time that we need to get through it. And I would enjoy doing it. So please, feel free to take the contact information. And if you have a question, certainly please give me a call. All right. So tonight's subject is uncontested, mediated, and litigated cases, and how each of those may impact your divorce, and what the difference is. A lot of times people call me up and they say, I want an uncontested divorce. And I think everybody wants an uncontested divorce, but whether or not your divorce is one that really is uncontested, that's the question. Mediated, we'll go through tonight what that means, and litigated, we'll go through that means. I do not have an agenda with these deep dive seminars. Tonight I do have an agenda, and that's to get people to consider mediation as a way of resolving their disputes with their spouse, incident, and as a consequence of a divorce. And so I am a divorce mediator. I am very pro mediation. It is an excellent way to get a result without spending a ton of money or a ton more money, where each spouse hires their own attorney. It's outside of the adversarial model. It's a cooperative model as opposed to an adversarial model. I have done multiple seminars, and my website is full of resources on litigation and what a litigated divorce looks like. In the prior seminar, um, I did a deep dive on what divorce litigation is and what an overview of a trial, what an overview of the entire process is. So tonight's um, presentation is going to be a little bit light on the litigation. All right, so let's get into what an uncontested divorce is. So an uncontested divorce is one where both spouses agree on every aspect of the divorce. They agree on how the house is going to get split, how they agree on how they're going to do parenting time, they agree on what the spouse support is, if there's any, what the child support is, they agree on what the retirement account is and how it's going to be split. So everything is agreed on. That's the essence of an uncontested divorce, that both spouses agree to everything. The situation I just described, where there's a retirement account and a house and kids, that is completely inappropriate for an uncontested divorce. Inevitably, once negotiations start in a serious way with a serious professional, both spouses are going to start to find that they have differences in opinion about where things should go or how things should be split up. So uncontested divorce could be either done by a lawyer or it could be done by the parties themselves. You don't necessarily need a lawyer, but the essence of it is that the parties agree to everything. And so the question becomes, when is a uncontested divorce appropriate? I have a very strong opinion about this, having done this for 30 years. An uncontested divorce is appropriate, whether it's done through a lawyer's office or somebody does it by downloading the forms from the state court system's websites. the Oregon State Judicial Department's website, is appropriate when people don't have any assets or have minimal assets. They have no debt or minimal debt, or they know who's going to take the debt. And they need the court to say, you're divorced. That's an appropriate situation for an uncontested divorce. If there's a home, unless one of the parties is going to take it outright, it's not appropriate for an uncontested divorce. When I say uncontested divorce, it occurs to me that an uncontested divorce is handled exactly the same way a litigated divorce is, except that the process is abridged, right? You're not going to go through discovery and exchanging a lot of information because both parties know how all of the assets and liabilities are going to get split. So it's the same process. It's just we agree, so we're going to sign the divorce decree, the general judgment of dissolution. And that's what an uncontested divorce is. It's like we both agree we're going to divide everything up like this. But once you start getting into the details, there's going to be differences of opinion about who should get what, or differences of opinion over what value is, what the value of the house is, what the value of the retirement account is, what the value of the pension is. So once those start to emerge, it's no longer uncontested. And again, uncontested, this is not again, an uncontested divorce can be prepared in one of two ways. One is where the forms are downloaded and people fill it out and sign it themselves. And the other way is where you hire a lawyer and the lawyer prepares the forms. When somebody calls me and says, I want an uncontested divorce, they retain me. The person who calls me, I become their lawyer with the understanding that I'm preparing the documents in a more or less neutral way to carry out what the client wants. And then once I've got that down, I'll send it to the spouse for the spouse's review. And if the spouse says, well, I want to change this a little bit, we'll go back and forth a little bit. And then we'll have the final judgment, and then I send it out for signatures. Once those come back, it goes to the court, and then it's done. That's the process. When an attorney is involved. Uncontested can be either done pro se, meaning on your own. And I'm not sure that's Latin for on your own, but that's what it means. Or it can be done through an attorney's office. I do not believe that a uncontested divorce is appropriate where there are children, where there's a house, where there's a retirement account, or any combination of those three. Particularly with children, there are so many decisions that have to be made that calling it an uncontested divorce is not really, it's not fair, because by the time you finish discussing who's going to get custody, and maybe custody is going to be modified a little bit, or the parenting plan, or the child support, all of those things have become just immensely complicated and require a certain amount of experience and skill and knowledge to put it together in a way that works for the couple going forward. So I'm not saying you can't, I'm not saying you can't do it on your own. I'm not saying that can't be an uncontested divorce, but I really don't recommend doing that without the assistance of an experienced attorney, an experienced family law lawyer. So again, in my mind, an uncontested divorce is where people agree on everything. Everything that's going to be divided, from spousal support to division of equity in the house, how the cars are going to get split and paid for, all of that. And that rarely, in my experience, that rarely happens as an uncontested divorce. Where it is appropriate is where the marriage is falling apart, and the parties need to be separated or want to be separated, and you need the paper from the court to say, we're you're now divorced and you can remarry. To my mind, that's an appropriate uncontested divorce. So to answer the question, yes, you can do an uncontested divorce without an attorney. You can download the forms from the state. And you can do it yourself. And then finally, how much does it cost? If you do it yourself, the filing fee is $301 and there's no cost to download the forms. If you wanted to hire me, for example, my fee is $3,000 just to do the straightforward divorce. And I do everything from drafting all the documents to paying getting the documents filed and paying the filing fee and then making corrections. Sometimes the courts will kick back documents because they're incomplete or you just missed something. And so I do all of that usually on a flat fee. If you're going to hire a lawyer who doesn't quote you a flat fee, be sure to pin down, what's included and how much time it will take. I used to work in a law firm that billed hourly, and the uncontested divorces there cost $7,000-8,000, and to my mind, that was beyond ludicrous and unreasonable. So you call around, ask, do you do these? How much does it cost? How many do you do? Things like that. Just to, be a good consumer. Let's talk about mediation. So like I said at the outset, I do a lot of mediation, and I usually don't come into these seminars with an agenda, but my agenda tonight is to get you out there to at least consider the possibility of mediating. Okay, so what is mediation? Mediation is a dispute resolution technique that involves a neutral third-party mediator going back and forth between the parties to effectuate a workable solution. That's mediation. Excuse me while I adjust. And so what I do is I help divorcing couples see ways forward, right? Like how the property is going to get split, how the spouse, what the amount of spousal support will be, how we're going to do a parenting plan for the kids. And I go back and forth, right? And I'll start with the wife, and then I'll go to the husband and say, wife wants X, Y, and Z, and husband will say, well, I'm willing to give A, B, and C, and we'll go back and forth until we get an agreement. Mediation works if the mediator is good when the mediator is filtering out the personalities and the conflict and just focusing on the solution and keeping the parties focused on the solution. The chief advantage of mediation is that the parties are always in control. Mediation is always a voluntary process. And parties generally can walk away from mediation if it's not going their way. Even in court mandated, sometimes the courts mandate that people who are going through divorce mediate. Even if you go through that process, although you have to be there, getting a result is voluntary. In other words, your spouse could be asking for something completely unreasonable, or you could be asking for something completely unreasonable, and neither of you agree. There's no harm that you've satisfied the court's requirement to mediate. So mediation is appropriate in most cases. There are very few cases that are not where it's not advantageous to mediate. So mediation can cover everything from, in the divorce setting, can cover everything from the kids and the parenting plan and the child support to spousal support to retirement plans, how the equity in the house is going to be split. Mediation will cover all of that. So generally, as a general rule, mediation is always available. There are certain circumstances, though, when it's not appropriate and it shouldn't not be used as a way of resolving disputes. One way is if you're certain that your spouse is not going to negotiate in good faith, or that your spouse is not going to produce documents that you need to assess value of things. So, for example, if a spouse doesn't know how much is owing on the home, on the mortgage, and the spouse, is not going to make that number available, then mediation is not appropriate. Mediation is also not appropriate where one of the spouses suspects that the other is hiding assets. So, for example, if somebody's secretive about money or refuses to share, and the spouse has some hesitancy that spouse is going to disclose everything, then mediation is not appropriate. That is because mediation is not a court process. It takes place outside of the court, and the lawyer or whoever is conducting mediation does not have the power to compel somebody to provide information the same way that a lawyer who's litigating, where cases filed before the court, does. When I litigate a case, when I'm representing a client before court, and I don't think that I'm getting the discovery, the information that I need from the other spouse, I can file a motion with the court. I can file a subpoena. I can call witnesses and put them under oath and ask them, right? So lawyer has a lot of power to get information that a mediator doesn't. The court process provides, it assumes that those tools are going to be necessary to get everything on the table and discover everything about the marriage. And mediation just does not have that power. So in those circumstances, mediation is not appropriate. A couple of other situations where mediation might not be appropriate is if one of the spouses is not competent to enter into a contract. Ultimately, you're going to need to sign a general judgment of dissolution, and you want to make sure that that's going to hold up later and not be subject to attack. And so you want to be sure that the person understands where their property is, what property they own, and that they're competent to sign a binding contract. Some one or two other areas that, or situations where mediation is not appropriate, would be in situations where there is significant domestic abuse and where there's a power advantage from one spouse over the other that cannot be overcome. Mediation is ideal where there's some domestic abuse or where there's going to be a power dynamic, and a good mediator can smooth that out and get the parties focused on the solutions and the information rather than the power dynamic. But if the power dynamic is that extreme, or one of the spouses is just in fear of the other spouse, then that spouse will need an advocate, not a mediator. That spouse needs somebody who's going to be in their corner and say, this is what we can do, right? And a mediator will not take that, will not and cannot become an advocate for either of the parties. And naturally, the dynamic is going to be that any person is going to start becoming sympathetic with the underdog. It's just, I think, human nature. And so once a mediator starts getting into that space, they're violating their obligation as a mediator not to take sides and to remain neutral. A good mediator can temper that and still act as a neutral and level the playing field. But if it's to the point where you're actually advocating, excuse me, I have an itchy nose there, then mediation is not appropriate in that situation. So to sum up, mediation is not appropriate when finances are unknown, when somebody is afraid that the spouse is going to hide assets or not produce information or not negotiate in good faith, or one of the parties is not intellectually competent, or where the power dynamic is too extreme to overcome at a mediation. So I started down this path a little while ago. The biggest advantage of mediation is that the parties control the outcome. That is the advantage. That at the end of the day, you have not gone to court and made your case and the judge ruled against you. In mediation, you are responsible for the outcome. You make the decisions, you advocate for yourself, and the final result is yours. As opposed to going to court where the judge may, could get it completely wrong. And, or, most judges will get things right. Most judges in this area have really, really good insight into family dynamics and family structure. A lot of the judges, particularly in counties with a family law department, have very experienced, sensitive, smart judges who handle these cases. Uh, um, and you will get, most people get a reasonable outcome. But there's an advantage to both parties by saying, you bought into this. This is your agreement. We made this together, as opposed to it being imposed by a third party, regardless of how neutral they are. The disadvantages of mediation, there are not a lot of disadvantages. The big disadvantage are what we covered just a moment ago in not having the ability to compel production of documents, or where the power dynamic is still going to bleed into the mediation in such a way that the mediator can't overcome like one side's onerous onerous treatment of the other spouse, and the other spouse is not strong enough to say, okay, I'm going to stand up for myself. So that's almost everything about mediation. A couple moments ago, I mentioned court mandated mediation, and every county in Oregon is required to have a alternative dispute resolution process that's mandated by the state. So every county has a way to keep cases from going before the court, and that's called alternative dispute resolution. In the family law realm, in the divorce realm, courts use mediation as a process, and every county has different requirements for who can mediate. So in Multnomah County, you can mediate over issues related to the kids, but not issues related to the property, or debt or house or anything like that. Washington County is different. Washington County, everybody has to go through mediation and mediate, and you can mediate on any particular topic in the marriage, from spousal support to division of the retirement accounts. That's mediation. And so now let's slide on over to litigation. Oh, no, I misspoke. There's more. We talked about domestic abuse and mediation, high conflict mediation, how mediation is conducted. I talked about this a little bit. In the old days, there were two ways that mediation could be conducted. And by old days, I mean pre-pandemic. The parties would get together at an office, and they would go into separate rooms, and the mediator literally would shuffle back and forth between them. And that was called shuttle mediation. And the mediator would bring proposals back and forth and back and forth. Some mediators have the parties together, and it's more like supervision or facilitating. And so they'll say, wife wants, $1,000 a month in spousal support for 5 years. And husband will say, that's outrageous. I can't pay that. I can pay 200. And the mediator will facilitate that discussion back and forth. And by facilitate, that means keeping the conversation focused on the negotiation and not personal attacks or attacks that go back and cover things that are not part of the mediation. And so the three people would sit down together and they would talk things through. I personally don't do that. I like putting people in separate rooms. That way I can talk to them and figure out where they are and how we can get things resolved. Now, personally, I do everything over Zoom, and I think a lot of people are doing everything over Zoom now. And Zoom has the advantage of parties can do it in their house when they're comfortable. They can do it in well, in a way that is just suited to them. They don't have to get dressed up. They don't have to go to court. They don't have to meet their spouse. They're doing it in a separate location from the spouse. And then they go into they log on and they go into separate breakout rooms on Zoom. And I'll have to talk to the spouse again. And I'll just shuffle back and forth between the breakout rooms, bringing proposals, weeding out the character assassination, and get a, just work towards a solution that way. Both in private mediation, not court mandated mediation, but in private mediation, like I do, both parties have to agree to mediate, right? You can't force somebody into mediation. Both parties have to sign a participation agreement saying, I agree to mediate. So both people have to be on board. How to find a qualified mediator is naturally, I think it's a good question because I wrote it. But there are multiple disciplines where people are mediating. There's therapists who do family law mediation. There's um, uh, clergy who do family law mediation. Obviously, there are lawyers who do mediation. My own view is that divorce is a legal process, and that somebody who knows what the law um, is the most qualified type of professional to do a mediation. It's not about, I mean, in some ways it's about preserving the relationship, but or what's left of the relationship. But you're not really looking forward to, the purpose of the divorce is to divide the property and future income and care for the kids. And so those are all legal issues. There may be some psychological relationship issues in that, but lawyers going to be able to get that and get that put into the document that you ultimately need. Best way to find a qualified mediator is just by calling around and seeing like how much mediation they're actually doing, what their commitment is to mediation as a profession. Are they involved with the professional organizations? Are they doing um, uh, uh, extracurricular things like with the bar? The bar has a lot of opportunities for people to mediate. And so you just want to check out people's credentials, asking them, how much they mediate, what kind of results they get, is perfectly fair. And you do want to find somebody who is familiar with the subject matter. So you want to find, even if it's you're going to the clergy, how much do they know about family law? Like that's not how much they know about children or relationships or relationship in context of their religious preferences, but how much they know about family law, because that's the bottom line, is the divorce is still going through the court. And so I guess the last thing would be just personal experience with mediation. I don't know what I meant by that. I don't recall. So I'm just going to go forward. Litigation. So like I said at the outset, I've done numerous talks on what litigation is. But the basic thing to remember about litigation, as opposed to doing an uncontested divorce or a mediation, is that litigation is the adversarial model. It's built on two lawyers arguing in court. And so the way that people know that I'm winning as a lawyer, and if I'm charging them $300 an hour to be their lawyer, is that I'm beating up their spouse, right? I'm getting stuff from the spouse. I mean, that's the whole point of being in court, is to win, and that means getting an advantage over the person who's going to be your ex-spouse. Maybe that's good. Maybe you like that, but that's expensive. It's stressful. It destroys the relationship. If there are kids, it makes future relationship that much harder. It takes years to rebuild the relationship if you're so inclined. People who divorce at one time loved each other. At one time, there was something in that relationship, that spark, that they loved. And now that the relationship is over, they see the person in a new light. And what I'm getting at is that at one point, the two people were compatible. Maybe the relationship didn't work out, but there was something there that attracted them deeply. And so I personally think that in most circumstances, people will eventually get back to an equilibrium. Maybe it's not in the relationship that they want, or they don't want that particular relationship. But many people, I think, there was something there at one point, and they can find that if they want to. And um, litigation stamps that out. It's such an onerous, ugly process that just stamps out that hope that you can at least go back to having some modicum of respect or some friendship or relationship going forward with the ex-spouse. I almost always talk about this, and it's how divorce cases end up in court. And if you think about it, it's like, why do the lawyers get to end a marriage? I mean, why isn't the accountants, or why isn't it the therapists, or why isn't the umpires, or why isn't it gladiators? You go hire a gladiator, and whoever gladiator is left gets all the stuff. Why did divorce end up as a legal proceeding? And the answer to that is that historically, marriage has been viewed as a contract. Even Oregon law says that a marriage in Oregon is a civil contract, meaning that the state has some investment in that contract. It's not a private contract. And so old cases discussed, whether or not the spouses lived up to their obligations. In old court cases, you had to prove fault, and that was because to breach a contract, you had to show that the other person had committed a fault. That was how you got out of a contract. And so applying contract law to divorce, you had to go to court and prove that the other person was at fault. I mean, how ugly is that? And you could lose, right? You didn't necessarily have to win. And imagine the ride home after going to court with your spouse to divorce them and calling them all kinds of names and saying you did all this conduct, and the judge or the jury didn't think that was fault. I mean, how awkward would that be, right? So we've got most states, I think all but, I forget the number, 13 or 17 states still do fault. There's political talk about bringing back fault to make divorce more difficult. But getting rid of fault means that you're going to get divorced once you file the paperwork. The court has to divorce you. Fault is not an element of divorce. But that's how divorce devolved into litigation. So because it's an adversarial model, both sides hire their own attorney. The attorneys then file the paperwork to get it started. They start the process off with a petition. Then the other side files a response. And then you go through discovery, you exchange discovery, you try to negotiate, and then you go to court if you can't agree. And then if you get a decision you don't like, you take it up to the Court of Appeals. If the person doesn't follow through with what they're obligated under the judgment, then you have to go through a process of enforcing the judgment. It's a lot. And like I've said, it is a stressful, time-consuming, crappy way to end a relationship. The advantages of litigation are that you have the right to compel production. If you don't know what's in the marriage, what the assets are, what the debt is, you can compel that from the other side. Many of the judges in the state are very good. Having a neutral third party make a decision may in fact be the best way to end up and get things divided. The drawbacks I've just covered. It's stressful, expensive, very expensive. A middle-class couple with average assets could spend $40,000 or more to litigate a case through trial. All right, that kind of wraps it up. So let me go through some of the conclusions. Uncontested divorces are available when there's no conflict over who's going to get what. And usually that's mostly going to be suited for very simple cases where there's very few assets to divide, or very few there's not very much money to be distributed. where there's no dispute over what's going to happen with the kids, with parenting time, spouse support, custody, or child support. And so uncontested is available either through an attorney or by downloading the forms, when really what you need is just the divorce and to split up the little bit of property that you may have. Mediation is generally always available, except when, like we talked about, you're not sure that your spouse is going to negotiate in good faith, disclose all the assets, is competent, or where the power dynamic is just too great. Those are situations where mediation is not appropriate. Litigation is the only one of these that is always available. You can always take your case to court. So I hope that helps. Like I said at the outset, I'll leave this up for a second. Please feel free to call me if you have questions. Just tell me, watch the webinar, the deep dive webinar. I'll be happy to work through your situation with you. You can visit my website at leskinlaw.com. You can also find it by typing in one-day divorce mediation, or give me a call or sending me an email at this address. So thank you for joining me tonight. I hope you found this educational, helpful, and good luck. Thanks.